Party peoples of the interwebs, Viva Frei, former Montreal litigator turned current Florida rumbler, in my outdoor office, the free state of Florida. By the way, if you see an alligator behind me, be sure to tell me. An update in the Brian Cole Jr. arrest and now detained until trial. You want to know what motivated reasoning looks like? I often refer to a concept as arguing from conclusions as opposed to towards them. When you want to arrive at a certain destination, well, it certainly makes it easier to get there when you start there and use every possible detour to get to where you wanted to get all along. Motivated reasoning, no better such example than the judgment in the January 6th pipe bomber case, which is now ordering the pretrial detention until trial of Brian Cole Jr., the 30-year-old autistic man alleged to have planted the January 6th pipe bombs. Now, back it up a little bit. Some of us, rightly or wrongly, believe that it's the wrong person outright, and that if there is any involvement, it's part and parcel of a broader conspiracy that might implicate other players. The evidence for that being that Brian Cole Jr., a man who was 25 years old at the time, apparently heavily autistic to the point where friends and family say he's got basically the cognitive capacity of a 15-year-old in a 30-year-old's body. He had been on the lam, undetected for 5 years, and only arrested based on information which already existed in the file about a month after Steve Baker from The Blaze put out an expose identifying who he believed to be the January 6th pipe bomber, and that was someone who was employed at the Capitol Police, now employed at the CIA, and a month later, the DOJ magically, mysteriously finds this man, Brian Cole Jr., to be the suspect. Now, there are a number of things that don't make a lick of sense in this case, not the least of which is how on earth a judge came to the conclusion that Brian Cole Jr. should be detained until trial because he cannot be released under proper circumstances. We'll get there. Some of the facts alleged that you all might want to pay attention to and just ask some reasonable questions about is the evidence against Brian Cole Jr. Now, recall, Brian Cole Jr. is alleged to have planted 2 pipe bombs on January 5th, which were discovered on January 6th. Discovered within 25 minutes of each other. Discovered, and there was no lockdown. There was no state of emergency declared that we must make sure there are no other pipe bombs. How the Capitol Police knew that there were 2 and only 2 pipe bombs placed that day, even if Brian Cole Jr. is the individual who planted them, you might want to ask yourself how that can be. The evidence. There's a nuance of this case which I don't yet fully appreciate, which is the fact that they went by way of affidavit for criminal complaint instead of a grand jury indictment, and they sought to get a grand jury indictment at the local level and not at the upper level. I don't appreciate that nuance yet, fully understand it in order to explain it, although I would suggest that everybody watch Viva and Barnes' Law for the People, the Sunday night show, every Sunday night, 6 o'clock Eastern. We're going to talk about that tonight, for sure. But I can't appreciate the evidence because I've read the affidavit. I've read the brief in support of pretrial detention. You might want to appreciate the evidence. It is alleged that Brian Cole Jr. bought the caps and the pipes upwards of 2 years before planting the bombs. It is alleged in the brief for detention before trial that Brian Cole Jr., after having signed away his Miranda rights, proceeded with a 4+ hour interrogation by authorities in which he admitted planting the bombs, how he allegedly put them together, etc., etc. The hard evidence is that he is alleged, based on receipts, to have purchased pipe components over 2 years leading up to January 6th. When I initially read the affidavit in support of the probable cause, I'm like, they didn't allege where he bought or if they have receipts for the sulfur, the potassium nitrate, the charcoal to the extent you're making black powder. And what I noticed in the brief in support of pretrial detention is that they slid in an allegation as to when Brian Cole Jr. bought the sulfur, which is a necessary ingredient to creating black powder, and they discreetly, or at least I only noticed it then, put into this brief in support of his pretrial detention that he's alleged to have bought the sulfur, which is actually nothing more than sulfur powder, which is a herbicide and a miticide. He's alleged to have bought it in January 2018. That is 3 years before having planted the pipe bombs, 1 to 2 years before having purchased, allegedly, the pipes and the caps, the steel wool, the glasses, because you need to buy security glasses when you're making black powder. They added that in So now we are led to believe that he purchased the sulfur a year before purchasing the pipe components, and we still don't have any receipts for the potassium nitrate, which is the critical component to making black powder. Set all that aside. He was before a judge who heard arguments in favor of and against pretrial detention. And I said, my goodness, I'm not even convinced that they have enough for probable cause to charge him, let alone to detain him pending trial. And lo and behold, this judge, whose name I forget at the moment, came to the conclusion that he must be detained pending trial. And you go to the last paragraph of this written order, and you can understand that the judge was arguing from a conclusion and not towards one. He wanted to come to a specific result, and hell or high water, he would get there by bending and twisting all of the facts and interpretations in favor of where he wanted to go, which was justifying pretrial detention. Now, the rule is, under the Constitution, no unreasonable bail, innocent until proven guilty. You get to go until you have your day in court. But the law creates some rebuttals of the presumption of liberation. If the crime is sufficiently serious, violent, etc., there is then a presumption against pretrial release that the defendant must rebut with evidence to the contrary to show why he ought to be released, notwithstanding the reversal of the presumption of free until convicted. And the judge came to the conclusion that the prosecutors, who were arguing the rebuttal of the presumption, had succeeded, and that the defendant failed in rebutting the reversal of the presumption of liberation, and that he failed to argue why he could be successfully released given the charges against him. Now, I actually wrote down the 4 criteria just so that I wouldn't make a mistake on it. And when you hear the 4 criteria that the judge considered and said, yep, all these criteria are met, but by the way, even if they hadn't been met, we would have still kept him locked up because Congress wanted it that way. The 4 criteria that defendant Brian Cole Jr., a 30-year-old autistic kid with no prior criminal record and no violence since the allegations or the alleged planting of the pipe bomb, failed to rebut these 4 criteria. 1, to consider the nature and circumstances of the charges against the defendant. The other is the weight of the evidence against the accused. The third is the history and characteristics of the accused. And the fourth is the danger to the community if released. Those are the 4 criteria that the judge considered in determining whether or not Brian Cole rebutted the reversal of the presumption of liberation. And the judge said, no, I can't get past all of these. The nature of the crimes, sufficiently heinous that we need to lock him up. The characteristics of the individual, Lord knows how he even got there. An autistic 30-year-old kid who had no prior criminal record and has had none since. The nature and characteristics of the individual warrant pretrial detention. That he'll pose a unmitigatable risk to the general population if he's released, warrants him being held in pretrial detention. Now, it's not to say that the feds don't have the best track record for maintaining the safety of defendants while they are in pretrial detention. Jeffrey Epstein, you're being paged right now, but they don't. Set that aside. This is an individual with no prior criminal record, who had done nothing since, done nothing to avoid arrest, although the argument is that nobody was looking for him, who is apparently sufficiently severely autistic that when he would go to the 7-Eleven, he would be borderline nonverbal, order the same thing every day, wear his headphones, heavily into video gaming, and this kid cannot be released to the general population because he would pose an unmitigatable risk to the population. And the judge says, yep, they have not succeeded in rebutting the presumption of all of these 4 criteria, but even if he had, we would have ordered him detained anyhow because Congress wanted it that way. It's an outrageous situation. I believe that he is either outright the wrong individual or is a patsy, as in used part and parcel of some broader plot here, which I do believe exists. And I appreciate it's my belief, and I don't have the evidence to support it except for some reasonable arguments, that there is no way Capitol Police could have known there were 2 and only 2 pipe bombs placed that day, to the extent that Brian Cole Jr., according to the allegations in the affidavit, purchased more than 2 pipes and more than 2 caps. And so there could very well have been 4, 5, 6 pipe bombs on that day, and Capitol Police found 2 within short proximity of one another, and then definitively knew there was no other issue here, no lockdown necessary, no continued searches. How? If you have an answer to that question, maybe you can convince me that Brian Cole Jr. should be detained pending trial, that he poses an unmitigatable risk to the general public. I think this is an outrage. I am mildly surprised to see all of those who were on board with appreciating, understanding the abuse of the judicial process against the January 6th defendants, all of a sudden now saying, yeah, lock this dude up until he has his day in court and then lock him up and find him guilty. I appreciate what Brian Cole Jr. is accused of is far more serious than what some of the other Jan 6ers were accused of, although bear in mind, some of them were accused of seditious conspiracy, very serious on paper. Plotting to overthrow the government, very serious on paper. I do acknowledge pipe bombs are a different animal than a bat, than pepper spray, than bear spray, etc. But on paper, all sufficiently scary. And now people are saying it's okay to lock up this kid pending trial. That they're okay with Jocelyn Ballantyne being the prosecutor of this case. Jocelyn Ballantyne being one of the prosecutors involved in coercing a fake plea, guilty plea from Michael Flynn. Jocelyn Ballantyne, the woman who was involved in the persecution of Enrique Tarrio and the Proud Boys, who sought to coerce, suborn a lie from Enrique Tarrio to incriminate Donald Trump. She's in on this case. She's the prosecutor on this case, and nobody's up in arms about that, and everybody's fine with locking some kid up until a trial, which can happen in a year or 2 years. I don't know how it works. I like to think I'm consistent in my intellectual analysis, and I like to think I'm being intellectually consistent right now, but perhaps I'm not, and perhaps I'm blinded by my own biases here, in which I think the Blaze and Steve Baker were closer to the truth than the current DOJ with Brian Cole Jr. But that's the update. If you like what I do, you know what to do. I love this place. Look how beautiful this is. Like, share, subscribe, drop a comment in the comment section below. Happy New Year yet again, and peace out, peeps. Booyah.